Good evening, everyone. Thank you so much for joining us today for our webinar on legal impacts of the coronavirus on small businesses and individuals. My name is Fawaz Baum. I am an attorney with Hunton Andrews Kurth here in Dallas, and I also serve on the firm's pro bono committee. Today's presentation is being put on in conjunction with our community partners, Wings and DVAP, both of whom have been intricately involved on the front lines of the Dallas community for years, and we're proud to be working alongside them. Just a couple of housekeeping items to get out of the way. This webinar and information being provided won't create any sort of attorney-client relationship between the volunteer attorneys presenting and the attendees. And also won't imply any legal services that would be provided in the future. As everyone can imagine, the information that we're going to present today is continually evolving and changing, and we want to make sure that all business owners and individuals seek professional guidance before embarking on a business decision. With having said that, we hope today's presentation provides vital information as a baseline for what business owners can expect and what individuals can find, and we hope this information is useful. Moving through, all lines are going to be muted. Just as a point of note, if you have a question, please submit it via the Q&A software. We'll monitor the same, and time permitting, we'll go ahead and answer as many questions as we can, and the session will be recorded. Here's a quick roadmap of today's topics. We'll be covering a few different ones: employment, leases, Dallas-specific orders, force majeure, and other legal concepts that a lot of you are hearing out there. The status of Dallas County courts and how that affects your rights, financial assistance resources that might be available in your area and in the Dallas County area, the stimulus package, also known as the CARES Act. We will discuss that from a legal perspective as well as a practical banker's perspective on how he sees the application process working and benefits for everyone. Lastly, we'll hear from Wings and DVAP regarding their organizations and what they're doing to help everyone during this pandemic. Also on the right side of the slide, you'll see the presenters that have spent quite a bit of time going through and researching these topics for us today, and we thank each and every one of them. Thank you.
With that, I'll turn it over to Riley to speak about employment.
Great, thanks Fawaz, and thanks everybody for joining us. We'll start kind of general here with obligations and things to think about when you are working in a pandemic situation, working during the coronavirus. So the number one thing that both employees and employers are concerned about is making sure that the workplace is safe. And the regulatory agency that enforces rules about safe workplaces is OSHA. So the primary concern here is the OSHA General Duty Clause. Under OSHA, all employers have a duty to provide a workplace free from recognized hazards that could cause serious injury or death. So unfortunately, COVID-19, the coronavirus, does qualify as one of those recognized hazards, and employers do have to take steps to keep the workplace safe. So one of those steps is enhanced cleaning and sanitizing procedures. Most of us know at this point that the coronavirus can spread person to person, but it can also spread on surfaces. So if you have shared surfaces in your office, bathroom areas, door handles, that kind of thing, you're going to want to make sure that you are cleaning those and sanitizing them, maybe even a little more than you normally would during a regular work week. Working from home is obviously a great option. It's been encouraged, if not required, by a lot of the stay-at-home orders that have happened both in Dallas and around the country. So if you do have the opportunity to allow your workforce to work from home, we recommend that you do that. To the extent your workers have to keep coming in or that you're an employee who has to keep going to work, we recommend following the social distancing guidelines, making sure that people are spread out 6 feet apart at least, preferably more. And one way to try to do that is through staggered shifts. So staggered shifts would be keeping your workplace open a little bit longer. Maybe instead of 9 to 5, you're open 7 to 7, and you allow employees to kind of come in during different windows of time in that larger block that you're open, so there are fewer people at the office at any one time. So maybe someone comes in from 7 to 3, somebody else comes in from 11 to 7, and then there's only minimal overlap between your entire workforce being at the office. Depending on the type of employer that you are, you may have additional OSHA obligations. Fawaz, I think we could go back there real quick. So there'll be a slide at the end of the presentation that we'll talk about quickly, the end of my section, that will show you the link to the OSHA guidance if you have a public-facing business, so like a grocery store or a pharmacy, or if you're in healthcare, there are obviously heightened workplace safety standards that you need to be aware of. So just keep that in mind if you're not in a traditional office environment. Another issue a lot of employees and employers are encountering is employees testing positive for coronavirus. So the first thing that you should do if you have an employee test positive is notify your local public health department. That's not required by law, but the local public health department is the most capable and really the department that's supposed to be handling how you respond to a positive test. So if you are able to reach your public health department, they can basically handle this notification process for you, take away a lot of the risk and the stress from the employer, and you know, tell you who to notify, what to tell those people that you do have to notify, how to handle returns to work. All that stuff can be handled by local public health. Now, obviously, as the illness becomes more prevalent, there may be times when public health is overwhelmed and you can't get in touch with them. In that case, you do have a notice to provide to provide notice to employees who may have been exposed to somebody who was testing positive for coronavirus. So number one thing to remember here is you cannot release the name or identity of the person who did test positive. You're going to want to use general terms. So you might say something like, an employee on the 3rd floor tested positive. He was last in the office on March 28th, and he began showing symptoms on March 30th. We believe you may have been in contact with this person, so you should monitor for symptoms. Generally, self-monitoring for symptoms is going to be what you recommend to employees unless they've had close contact with that person. So close contact generally means either some kind of direct interaction where there was a sneeze or a cough, or you shared utensils or something unusual like that, or where you were having a face-to-face conversation for more than a few minutes, maybe 10 minutes. If you were in a one-on-one meeting with somebody who later tested positive, that's going to be considered close contact under the CDC guidelines. And at that point, you're probably going to want that person to self-quarantine for 14 days. Again, follow the CDC guidelines, but if you can get in touch with local public health, that's kind of your best option. Employees with symptoms who haven't tested positive, you don't have a notice obligation to other employees. So if somebody calls you and says, hey, I can't come in today, I'm really sick, I'm worried I might have COVID-19, at that point, there is no obligation to notify other employees, but you should obviously tell that employee to stay home, not come into work, and if the symptoms are consistent with COVID-19, then that employee should not return to work until they've been symptom-free for 7 days. So we'll move to the next slide here. Americans with Disabilities Act compliance. The ADA is going to come up quite a bit in coronavirus situations. Number one issue with the ADA is employee privacy. We already talked about that a little bit with positive tests, but it may also come up with suspected COVID-19 cases or with folks who have other high-risk medical conditions. So if an employee comes to you and says, I have asthma, I have other respiratory trouble, I'm afraid to come to work, I need an accommodation, that's something that you need to make sure you keep close to the vest. You only share as a need-to-know basis with maybe HR or other management folks who have a need to know. In terms of reasonable accommodations, this is a situation where an employee with an underlying medical condition may qualify for a reasonable accommodation, either to work different hours, to work from home, to protect them from potential exposure to COVID-19. We recommend that you have employees come to you, or if you're an employee, that you go make a reasonable accommodation request, not that as an employer you suggest to an employee that they should consider a reasonable accommodation. It's really on the employee to make that decision. And you don't want to be making any assumptions about somebody's condition that could lead to a discrimination claim if you suggest that they should take leave because of a high risk condition. Employee temperature testing, generally we don't advise that. We know it's becoming a little bit more common, and if the Dallas County Health Department does eventually advise it, then it may be something that becomes a practical concern for employees and employers. Again, confidentiality comes into play here, but there's also some practical difficulties with temperature testing. So obviously, if you have somebody taking the temperature of everyone coming into work, that person is going to be exposed to every single employee who comes to work in pretty close interaction. So you really want that person to make sure they're wearing proper personal protective equipment, that they're properly trained. Ideally, if possible, you would use a medical professional or somebody who's trained in medicine. Obviously, most employers aren't going to have that resource available. Another option is to allow employees to self-administer the test themselves. So they would take their own temperature, then show the results to a supervisor, and then that supervisor could allow them to continue working or ask them to go home. One more thing to consider there is that you really need to have a reliable test, because if you are going to exclude someone from working based on a temperature screening, you're going to have to be able to defend the process that you use to make that decision. So you're going to want to make sure that your thermometers or whatever you're using is reliable. Can move to the next one. Families First Coronavirus Response Act. This is the piece of legislation that Congress passed, one of the first pieces they passed in response to the coronavirus, that applies to paid sick leave and family leave. So this law applies to all employers, nonprofit, for-profit, most government employers, although there are some exceptions for federal government employees. If you have fewer than 500 employees, you probably have to comply with this law. First provision is paid sick leave. This is 2 weeks, up to 80 hours for a full-time employee of paid sick leave at 100% of the employee's rate of pay for coronavirus qualifying conditions. So that could be being ordered to be quarantined by a federal, local, or state government, being ordered to quarantine by a doctor, seeking a coronavirus diagnosis if you have symptoms like a fever or a dry cough, and you need to take off work to try to get diagnosed. You can use the leave for that. You can use the leave to care for a person who has coronavirus and is under a quarantine order, or you can use the leave if your child is out of school or daycare for coronavirus reasons. So that's up to 2 weeks of leave. Then in addition to that, there's the family medical leave expansion. That provides an additional 10 weeks of leave, but it is only available if you need it to care for a child who is out of school or daycare because of coronavirus closings. You will need to certify, if you're an employee taking that leave, that there's no one else who can take care of the child and that there's actually a demonstrated need to take that leave. So if you have a domestic partner or if you have a grandparent who can watch the child and you're taking the leave more for convenience than for need, then it can be denied by the employer and not necessarily available. And that leave under the Family Medical Act is still paid, which is not how family leave usually works, but it's only paid at 2/3 of an employee's usual rate, not their full rate. And there are caps on that daily. So, if you make more than a certain amount, you may not get actually 100% of your pay for paid sick leave. Unfortunately, a lot of employers are also thinking about layoffs versus furloughs at this time, workforce reductions because of payroll issues. And some folks will talk about the CARES Act a little bit later on in the presentation, and some reasons that you may not want to lay off or furlough folks. But to make sure people aren't working while they're on furlough. Employees still are probably eligible for unemployment while they're on furlough, and they can likely maintain their benefits, although you should make sure you check the terms of your plan, if you have a health plan, to make sure to ineligibility. A layoff is a full separation of employment. One of the big issues with layoffs is you may have to pay out accrued, unused, paid time off. So under Texas law, that's governed by the terms of your policy. If you're an employee at separation, we will pay you that time. Then you are obligated to pay out that time when you separate. If your policy is silent on that, or if it says it's not going to pay out, under Texas law, you generally don't have to pay that out. But it is an extra expense to keep in mind if you go through layoffs. Obviously, at the end of the coronavirus process, if you want to hire people back, if you lay them off, you have to go through the full hiring process again, get their paperwork, do their interviews, get their application, all that stuff. Laid off employees would obviously be fully eligible for unemployment, and you may have, depending on how many employees are involved, Federal WARN Act concerns that require you to give notice if you're going to lay off several people at one time. Dallas shelter-in-place order. So obviously, the mayor Dallas issued some directives about businesses that are allowed to stay open and businesses that have to close. You should review that to see whether you're an employer that's allowed to continue to operate, or if you're an employee of one of those employers that's allowed to continue to operate. There is an explicit list in the Dallas order about businesses that can't operate. So certainly if you're on that list, if you fit squarely on that list, you really shouldn't be operating. If you're not sure, then you can, potentially try to fit into one of the categories that is deemed essential. But again, you should kind of probably use common sense on that. And if you're more like a business that's on the non-essential list, then it may make sense not to have your employees come in. And obviously these are closings that are related to physical appearance at work. So if you are allowed to, or if you're capable of continuing to function in a telecommuting environment, you can still do that, even if you would otherwise be on a non-essential business list. A few resources available for you as an employer or an employee. The CDC interim guidance for businesses will kind of spell out return to work, sending people off from work, those kind of issues. If you follow the CDC, you're probably in good shape in terms of having a defensible process for the workplace. OSHA guidelines that I mentioned before, you can check them out there. And then the Texas Workforce Commission also has coronavirus specific guidance for employers and for employees on twc.tech.
Thanks, Riley. Hi, my name is Anthony Bonan. I'm an attorney at the Hunton, New York office, and I'm going to talk this evening about the different rights and strategies that tenants can expect to have with respect to what's going on now with COVID-19. So first, I'm going to talk about the rights that you may find under your lease, both for residential and commercial tenants. Residential tenants generally are not going to have a right under their lease to stop paying rent on account of COVID-19. That's unless, of course, a landlord is failing to do what they're required to do under the lease, which could include anything from providing services to picking up garbage, performing repairs and maintenance, providing building security and other amenities. So if a landlord is actually failing to provide one of the services or other obligations that they're required to under their lease because of COVID-19 or for any other reason, you may have a claim there for a constructive eviction, which would allow you to take a rent abatement, meaning you don't have to pay rent while that service is discontinued. But in the absence of that, you're probably not going to have a right under your lease to stop paying rent. Commercial tenants, like residential tenants, you can expect are not going to have rights under their lease to stop paying rent in the absence of a landlord failing to provide a service. However, the situation is going to be a little different with commercial tenants because, as we all know at this point, there are stay-at-home orders, which could perhaps lead to a claim that the tenant is not able to use their space because they're being prohibited to coming into the office. And there is a doctrine called frustration of purpose, where if someone under a contract is prevented from enjoying the benefit of that contract in its entirety, they could have a claim that the contract is void on those grounds. Now, frustration of purpose is construed very narrowly by the courts. So you're only going to get this most likely with a very short-term lease, where the order is in place really for the entire term of the lease. So if you have a 10-year lease and this is preventing you from using the space for 2 months, this probably is not going to apply. However, one other case where commercial tenants may have a claim under their lease here is if the landlord is unilaterally determining to close down the building. In that case, where it's not it's not a stay-at-home order in place that's preventing you from using your space, but the landlord himself is saying, hey, I don't think it's safe, I'm going to close down my building. In that case, you would have a claim for constructive eviction. And that, again, would allow you to stop paying your rent. Fawaz, can you turn to the next slide, please? So those are the rights that you're going to find under your lease. Practically, what can you do, though, in this case? Now, even though, doctrine of frustration of purpose probably doesn't apply, that is a claim that you can make, and you can use that to start a conversation with your landlord. And even if you're not in a situation where you're being prevented from using your space, but just you're having trouble paying your rent, you're going to want to start a conversation with your landlord as soon as possible. Now, you can ask for relief, but if you actually stop paying your rent, you're going to just want you to be aware that you're going to be at risk of defaulting under your lease, and that could trigger some serious penalties, including late payment fees, default interest, loss of maybe your renewal or expansion rights, if that's something you have in your lease. So if you go into default, you can expect that there will be penalties. And finally, of course, the landlord can accelerate the rent and evict you if you really fall behind. So tenants who are having this conversation with their landlords, what are some of the things that they can ask for? They can ask for a rent abatement. That's where the tenant is no longer required to pay rent for a period of time, or a rent deferral. That would be where instead of paying the rent now, you're deferring that payment till later. Or you could ask for some sort of a restructuring of your rent, that maybe if you're a retail tenant, it's based on your revenue at a later date. So to make up that rent that is lost now, maybe the landlord will agree to pay that at a later date. Finally, just to mention, all this advice is really general in its nature. You really need to be carefully reviewing your lease in light of what's going on and in light of the pertinent facts, and determining a strategy based on that, and then reaching out to your landlord to start discussions. Thank you.
I'm Kate Eberhardt, and I'm also from Hunton Andrews First, and I'm also in the Dallas office. And first, I just want to start off by saying I really want to emphasize the practical tips Anthony just went over. Those are great to keep in mind, as we all work through this time together. What I'm going to talk about is what's going on both a state and a local level. It's probably easiest if I first just go through this based on timeline. So March 12th, which seems like a very, very long time ago now, Dallas County Judge Clay Jenkins declared a local disaster, which he's permitted to do under the Texas Government Code. And that is what gave him the ability to make the first ordinance, which was no gatherings of more than 500 people. The next day, on March 13th, that is when Texas Governor Greg Abbott declared a state of emergency, so for the entire state, not just Dallas. And by doing that, the governor gave the authority to the Supreme Court of Texas to make emergency orders as needed. So then the 17th is when our mayor of Dallas, Eric Johnson, he created 2 ad hoc committees. These committees are subsections of the City Council. So one is called the Ad Hoc Committee on COVID-19 for Economic Recovery and Assistance, and the other one is the Ad Hoc Committee on COVID-19 for Human and Social Recovery and Assistance. So slightly different, but a lot of overlap there. And both of those committees meet by a schedule that is posted on the City Hall website. They publish an agenda, which is sometimes a bit vague, sometimes intentionally, just the way politics work. In the state of Texas, all of our government bodies, so from up to the state level as well as to the local municipalities, are subject to what's called the Open Meetings Act, which is Chapter 551 of the Texas Government Code. And under the Government Code, it is required that before a meeting of a state or local body, they have to publish 72 hours before the meeting what is on the agenda. Now, there is a carve-out, and the carve-out is an epidemic, and that's where we are. So right now, the city of Dallas has been diligently trying to go with this 72-hour rule, but in the event that things come up, there is the ability to change things at the last minute. The only rule is that they have to act in good faith. So back to my timeline. On the 18th is when the Texas Supreme Court issued what they call Emergency Order Number 4. And under Emergency Order Number 4 is when they mandated that there will be no residential eviction filing until April 19th. And I think you'll hear some more about this later in the presentation. On that same day, March 18th, Judge Clay Jenkins also ordered that there would be no hearing or writs of possession filed in the Texas court, so the Justice of the Peace could not hear any case for 60 days. So while the state gave a smaller deadline of just 30 days, the local level extended it out for 60 days. So while at the same time your rent doesn't go away, it's just that they're not going to lock you out, and it is only residential. Now, yesterday, Mayor Eric Johnson had a press conference where he asked landlords to have a heart. And I know that doesn't really bring a lot of comfort to a lot of people, but from talking to local activists and from talking to my own city councilman, which is Chad West, I live in Oak Cliff, the sense is that the mayor would like the city council to really take time to think through what the implications are going to be. Now, the Ad Hoc Committee on Social Recovery and Assistance is meeting tomorrow via teleconference at 1:15, and on their published agenda, they do have an item that reads, briefing on federal relief package as relates to funding sources for human and social needs. This is a very vague line item, but in there is when it is expected to discuss some of the financial bailout package stimulus, what might be coming from the federal government to sort of make it where everybody in the chain feels the pain, but it doesn't fall on one party. Because if the renter doesn't pay the landlord can't pay the bank. So like the news keeps saying, we're all in this together. One thing that the restaurant industry did was they banded together and asked for assistance. Well, actually, they asked for all sales tax payments to be relieved, or at least deferred payment. And the Texas Comptroller's office said that sales tax is such a large amount of the revenue that comes in to the state of Texas that they can't just defer it. But they are allowing payment plans. So if you're in a situation where you're having some problems paying your sales tax, on this slide I've got the number for the Texas Comptroller's office. give them a call. In those instances, they're waiving penalties and interest. I'd also just like to tell everybody to make sure you know who your city councilman is and that you are communicating what your needs are. They're there for us, and you can look it up online, see who they are, call their office. You're always available. You're always allowed to go to a city hall meeting and speak. Usually it's a 24-hour requirement to get on the list, but that's something you can do to advocate for your business or for yourself.
So it's really, really, really important that you read your particular lease. Every lease is different, but most leases have a concept of what we call force majeure. And what that means is, and I've got some language on the slide, but for unforeseen circumstances, we call them, acts of God. That's a hurricane, that's a tornado. Also for labor strikes and different government, it does sometimes say government restrictions, but whether this would actually apply is unknown because we're in unknown territory, but probably unlikely. This is really for, like I said, hurricanes, tornadoes, that sort of thing, but also, for a car manufacturer, if there's a labor strike, well, then the car manufacturer can no longer deliver according to their contract. So they would be given, well, depending on what their contract says, but in many cases, they'll be given a day-for-day delay. So because the labor strike goes on for a week, then they have another week to fulfill their contract. It's also important to read your lease because sometimes in order to enact or to trigger the force majeure provision, you have got to give notice upon the occurrence of the event, and that can be within a couple days. So that is definitely, if you miss that, you may waive that right. Furthermore, there's a number of leases that I've looked at recently, mostly for restaurants, that say, specifically carve out, no matter what, this does not release any monetary obligations. So it's making sure that the landlord gets paid, and then the landlord can pay on their loan, and the bank gets paid, and the system all goes together. On the next slide, I want to follow up on something that Anthony said. So while there are laws that are cases that are based on exactly what is written in your contract, there's also what we refer to as common law. And what common law is, are there principles that judges use to decide what is fair. A lot of them tie back to the English system that America came from, and the three that I wanted to mention were impracticability, frustration of purpose, which Anthony mentioned, and prevention by government regulation. And all three of these are based on a non-occurrence of an event that was an assumption when you made the contract. And while we would definitely say no one expected this to happen, in the case law in Texas, these concepts are really brought in when there's a new law. So for example, when in Texas, when energy was deregulated, there were some changes in the way that contracts had to be done, and the way that certain contracts were set up were no longer a possibility. So in that case, it wasn't possible due to new government regulation. There's also some other issues with the loans. So these are all great concepts, and kind of like some of the practical tips Anthony gave, it's always a good idea to push whatever you can in your favor to try and advance your position. And I think that is Grayson next to talk about the Dallas court system.
Absolutely. Thank you so much, Kate. Moving through, let me unmute Grayson.
Thank you. Hey, everybody. My name is Grayson Linyard. I'm an attorney at Hunton. I practice in Dallas with Kate and Fawaz. I do litigation, so just want to give you an update on the Dallas County courts and some issues like that. I know the epidemic has kind of shut the city down in a lot of ways, but the Dallas County courts are not shut down. Business continues. If you have a lawsuit, it's still ongoing. If you want to file a lawsuit, you can still file it. If you've been served with a lawsuit, you still got to respond to it. All those things. Court is going on generally, civil courts. A lot of the courts are having telephonic hearings, right, to prevent gatherings of certain people. Certain courts may be closed for the time period. They've left that up to the certain judge. Each court here, either the county court number 1, 2, 3, 4, 5, or the civil district court, which will have a number. They each have a judge that's assigned to them, and they have the discretion to be open or limit their hours. But I will say that the courthouse staff is limited. Some of those people are working from home. A lot of the court clerks are working from home. So the wheels are still turning, but there's not quite as many people at the courthouse. And to that end, jury trials, if you had a jury trial scheduled sometime in late March or April or up through May 8th, those are off. They're going to be rescheduled. If you had a hearing scheduled, it may still be scheduled. You should check on that. A lot of the hearings are being by telephone. In the civil courts, a lot of times you needed to, if you filed a motion for something, you would need to get a hearing to have that heard and ruled on. Now, to prevent more people from appearing at the courthouse, they're starting to do what they call just rule on the papers, right? They'll just read your motion and the response, and then they'll decide it without the parties having to come down to the courthouse. So if you have a case that's ongoing, kind of like I said, this stay-at-home order and things, that doesn't really affect it that much. Your judge, you will have a judge that's assigned to your court. They may have put out specific orders about when they're open or closed or how certain things will be filed. So if you're doing the case yourself, I would encourage you to check on that. If you have a lawyer, make sure they're checking on the court's website, things like that, to make sure they're up on it. The main thing is make sure you're on top of the deadlines, right? Deadlines are still in effect. And so the last thing you want to do is say, well, county's closed, everything's on hold for a month or 2 months, so I don't need to worry about that. You need to specifically look at the deadlines in your case, the scheduling order, things like that. If you have a contractual dispute about to arise, I would say, as I always say, the best advice is try to avoid litigation if you can. If there's any way that you can avoid the time and expense of a lawsuit, that's the best way to go about it. Try to work it out some other way. I think especially in this climate, I think it's necessary to look at the big picture. You always want to think about, before you send an email or a letter or take a certain action, how is this going to play out if I'm standing before a jury or a judge and having to explain my position and what I did? And if it sounds reasonable and justifiable, then that's good. If it doesn't look great, and I think that courts and juries in the future are gonna, they're people too, so they're living through this as well, and so they'll take that into consideration. I think that's worthwhile to consider anytime before you file a lawsuit, but also in this climate. I'll just cut to the next one. Kate mentioned the eviction stops, and I want to be real clear here, and Kate was too. This does not mean that rent is not coming due. Okay, there is a moratorium on that, the actual eviction proceedings in the court. There is not a moratorium on rent, and so the eviction ban, kind of like Kate said, there's going to be no trials, hearings, proceedings until after April 19th. There is an exception to that. You can still get an eviction or be evicted if somebody files a sworn complaint that there's physical violence or criminal activity, but that's a pretty high bar. All the current eviction cases leases are postponed for 60 days. So just to be clear, rent is still coming due, but you will not be hauled into court, or the police aren't going to knock on your door for 60 days. This doesn't apply to commercial leases. That's different. What I would say in that context, like Kate said, there are defenses. You would need to look at your lease, look at the force majeure clause. There are other common law defenses, impossibility, impracticability, sometimes called frustration of purpose. Those are tough, like Kate said, but they do exist. And so if you're talking to a landlord, I will push those buttons, just like Kate said, throw out force majeure, throw out frustration of purpose. Just to get the conversation going. Because again, the best way to get through this is to come to an agreement. They don't want to go through the process of an eviction. You obviously don't want to do that either. Or if you're the landlord, same thing applies really. You're going to be in the same situation where there's probably not somebody who's ready to move into that space if you get somebody out in the next 30 days. I mean, maybe, but you have to consider the whole environment. And then while that's going on, let's say you do talk to your landlord or you talk to your tenants and you say, yeah, all right, I'll take half rent for May. Please get that in writing. Okay. You need to get something in writing, to something that you can point to later if somebody says, no, I never said that. Then just general last tip I would throw out is you always want to be the reasonable one, acting in good faith. And so while you're putting together your plans or your proposals or your conversations with whoever on the other side of a contract, I think it's worthwhile for your later litigation posture if you can point to your actions or your writings or those type of things and say, look, this was me. I was being reasonable. The whole time. And I think juries and courts will have a sympathetic ear for this because, like I said, it's a human system. We are all in this together. And that's what I would say about that.
Great. Thank you, Grayson, so much. Just a quick slide on other financial assistance that is available and resources. If you go to dallascityhall.com, they've got a coronavirus resource page. I highly advise you guys to take a look at that. They keep updating it every day, but essentially a lot of services like the Dallas Water Utility, Atmos Energy, TXU, and other electricity providers that are offering programs, deferring payments, proactive. AT&T also has a offer for reasonable internet, given the fact that a lot of people are working from home and maybe living in communities where they didn't have readily available internet. So just as a FYI, checking out in connection with all the other materials that we have been providing and links and resources, don't forget about the Dallas City Hall Coronavirus Response Center. Next up, Dee will talk about the
I think you cut out. This is Dean Elizev from Hunton in the Austin office. Can you hear me?
Yes, we can.
Okay, just confirming. All right, so I'm here to talk about the stimulus package under the CARES Act and specifically the Paycheck Protection Program from the Small Business Administration. So under the CARES Act, which was passed last Friday, they created a $350 billion Paycheck Protection Program. This is essentially a grant program where the lenders will be helping borrowers get roughly roughly the 2.5 months of their payroll costs and have that loan forgiven. So under this, you see that there's new lenders that will be coming in. So it's not just current SBA lenders, but also new lenders will be coming in to do this program. It reduces the requirements to qualify as a borrower under this loan program as opposed to traditional 7A loans. It also just increases 7A loans maximum loan amount and reduces the applicable interest rate. So there's a lot of benefit to this for small business owners to look into. We can go to the next slide. So one of the things is that this covered period is currently set from February 15th until June 30th, but Congress has the authority to extend it. However, one of the biggest fears is that the funding cap will be reached very quickly. So we are encouraging everyone to look into this program as soon as possible and to determine if they want to work with their lender to apply. The borrower application is already out on the US Treasury website. And so you can already start looking at that as a borrower with some limited guidance and determine if you want to do this. Next slide, please. So these are some more, this is all a lot longer in the actual slides. So I'm just kind of skimming through, but you can look at this yourself as well. So these loans, the maximum loan amount is going to be either $10 million or 2.5 times the average monthly payroll cost for the company. So there's some other calculations based off of being a seasonal company, a highly seasonal company, or a new company, but it's going to be roughly 2.5 months of your payroll. Both small businesses as well as sole proprietorships and independent contractors, self-employed, are all going to be able to apply under this. For small businesses and sole proprietorships, they can start applying on April 3rd to SBA lenders that are already authorized. And then independent contractors and the self-employed can do it next week. It is unclear right now when the additional wave of lenders will be able to start providing these loans, but the Treasury will update once they've decided when those entities will start joining in. So next slide. Okay, so very quickly, once you get the loan, you can use this loan for your payroll costs, interest on your mortgage obligations, your rent, and utilities. So that's what the proceeds are used for. Payroll costs include traditional things such as salary, wages, commissions, also includes employee benefits, state and local taxes, and a special carve out for sole proprietors and independent contractors. So you're looking to use this money traditionally just to get through your overhead and your payroll. Next slide. Okay, and then the one of the bigger features of this and what has everyone talking is the fact that a portion of the loan that the borrower will be completely forgiven, and the forgiveness is based on the sum of the payroll costs plus the interest on mortgage plus rent and utilities. This means that if set up correctly, the forgiveness amount will be the same as the borrowed amount, essentially making the money borrowed by the borrower a grant. However, there are a couple of complications to the formula, including the fact that the borrower needs to maintain current levels of employees and compensation. So the borrower can't go ahead and get a loan and then start firing people or reduce compensation. If they do that, the amount of forgiveness will also be reduced. So also there's a 25% cap on using forgiveness portions outside of the actual payroll. So that is an incentive to not get this loan and then say spend it all on rent or mortgage or utilities. They want this money going to payroll, and they want this money going to borrowers to make sure their employees are staying employed. And then the final slide is just that the borrower will need to work with their lender for this forgiveness amount. One of the things that we don't know yet, and we're waiting for the actual guidance, is just how the lender and borrower relationship is going to work and who's going to be asking for documents and what kind of documents they need. We think this is going to be a highly ad hoc and factual process that will be based on what the lender is comfortable with. And then, let's see, quickly we'll go through who qualifies. So they're currently qualifying all businesses, not-for-profits, and veteran organizations that were in operation before February 15th. They want to look at a company that has 500 or lower employees, or if that business is under an NAICS code, they have certain restrictions based off of that. So certain types of industries may be able to have more than 500 employees and still be considered a small business. Also, there's a somewhat complicated affiliation structure. So they just want to make sure that if a company is under common ownership with multiple companies, those employees may all get aggregated for the purpose of determining if any one of those companies is considered a small business. That just prevents a large network of commonly controlled companies that essentially grow out of the term small business from each applying for these loans because of their broken up nature. And then for this last slide, that's pretty much it, except for one more thing, is that the traditional 7A loans usually have the borrower determine factually that they cannot get credit elsewhere. They have exhausted all other options. This Paycheck Protection Program does not have that requirement. You do not have to prove that you cannot get credit elsewhere before applying for this loan. And with that, I would like to pass it off to talk about some more practical applications of this CARES Act.
Thank you, Dean. Pat, if you want to chime in on the practical nature and the application process you might be seeing. Might still be on mute, Pat.
Hold on just a minute.
We hear you now.
You hear me now? You got me now?
Definitely.
Okay, thank you. The Treasury Department put out the application late yesterday along with instructions to borrowers about the program as well as lenders, and indicated in those instructions that SBA lenders will be accepting applications this Friday. I will tell you that as we sit here right now, I do not know a single SBA lender that will be in a position to accept an application on Friday. As the Treasury Department and the SBA didn't check with a single lender about whether or not that process could be in place in 2 business days. It cannot. A lot of lenders are working fast and furiously to automate the process. There may be some that will be in a position to accept applications on Friday. Our bank, for example, maybe we're probably looking more realistically at Monday. But the other information that lenders are lacking right now is specifically what documentation can be relied on to calculate the 2.5 times payroll. A sole proprietor, which, someone who files their business tax return on Schedule C of their personal tax return, they may not have a payroll provider. They may not have those kinds of records that a larger business who has ADP or Paychecks or some other payroll provider who can spit out some reports that lists number of employees, which will be a required element, and then all of the wages, salaries per employee, and benefits and so forth that go into the calculation. There will be a lot of people who don't actually get that information unless sort of quarterly when they file their payroll tax remittances with the IRS. And there's still an open question about whether or not 2019, that document is called a 941 quarterly tax filing. There's still an open question as to whether or not that document will work, since it won't cover the period through February 15th when the lender is required to verify that the business was in existence. These are a few of the practical aspects that were left out of of the process. And there's a legitimate reason that they were left out. The SBA, when they move quickly, it's usually on other matters, it's usually a 30-day process because it's complicated. And I'm not criticizing the SBA. I'm in fact defending them in that the legislation was enacted last Friday, and the Treasury Department, who was put in charge of it, was telling the public in press releases that money would be available this week. And that, just as a practical matter, doesn't happen on a government guaranteed program. The fact that I think that as a practical matter, it's not only our bank. I've checked most of the really large banks, B of A, Chase. Their websites right now either don't even address it, or just like ours says, we're working as fast as we can to accept applications, and we'll let you know when we can and come back for more information. But there's another large bank, it's Chase, and they've put on their website, we will not accept paper applications. Don't send them to us. We're getting paper applications now. I think that the concern that some have had over the last several days about the $349 billion, which will be available for this program, will go pretty quickly. I think that concern might be a little bit overstated. I don't think you have to have your application in on Friday or Monday or Tuesday to be guaranteed funds. I think it'll take a little bit longer to subscribe up. It may even be available because of some provisions that they put into the final guide or the initial guidance that was distributed yesterday. But what I would encourage anyone to do is to contact their current bank because a large number of banks, including ourselves, in order to ensure that we're meeting our current customers' needs, are going to initially accept applications from current loan or business customers of the bank, just to ensure that we're allocating these available resources that help our current customers the most. And then if there's resources available later, we and other banks may open applications up to all comers.
That's a really good analysis, Pat. Thank you so much. One question that had kind of popped through was, does TBank have a calculator that folks can go on to your site and estimate what they might be eligible for?
If you go to www.tbank.com, we have, and I'm proud to say we're one of the few banks that have available today a calculator. It is not an application. It's quite accurate if you've got, and we have some suggestions for backup documentation to use to get the data to put into the calculator. But I want to qualify that those are just suggestions until we get SBA guidance on the actual documents that we will be required to review to confirm the loan amount. They may change. But we've had a number of emails coming in saying that the calculator has been enormously helpful. And so I would encourage folks to go out there and apply, or not apply, I should say, use the calculator for informational purposes.
That's great. That's really helpful. And that's just for folks that might not have written it down. It's T as in Tom Bank. And that's where you can use the calculator. And Pat, would you suggest folks to use this time before the applications open up to gather as many documents as they can and be prepared with multiple sources of backup for when all banks do actually open up their application process, that everything's kind of handy?
That's absolutely good advice. Rather than wait to see what will be accepted, there's not that many sources. So we believe that a business financial statement that's prepared by the applicant that has those line items may be acceptable. We'll see if you've got that. If you've got a draft of a 2019 tax return for your business that's not yet filed, because it doesn't have to be because they extended the guideline, that may be a useful tool. Your IRS 941 quarterly tax forms, if you haven't kept them, I believe those might be available off of the IRS website for your business based on your EID number. And then if you have QuickBooks and it has payroll data and lists employees, that could be a potential source. And then obviously, if you do have a payroll company, get familiar with the reports that they have available to you and gather them up, because every lender will have to verify the number of employees at February 15th and the total payroll for those employees and other associated benefits that are eligible at February 15th, because come loan forgiveness time, it's the data during the period after you got the loan, for the 8 weeks after the loan is received, the number of employees and the payroll expenditures to them becomes part of the equation to calculate the required information and equation to calculate the amount of forgiveness on the loan. So start gathering the data now. More is better than not having it when it's needed.
That's really great advice, Pat. And the only last question here before we move on to Donna, how quickly would you anticipate, once banks open up taking on applications, would you say from the application to divvying out the actual loan proceeds? Do you have an estimate on what the timeline is envisioned to be at this moment?
That process could be quite short for a bank that's putting in an automated process, and that's what we're doing. I assume a lot of the larger lenders, one of the reasons they may not accept applications on Friday is because they want to shorten that time frame and create some automation. One of the great things about the program is there's no credit report required. There's no business financial information relating to profitability or balance sheets required like a traditional 7A loan. So there's really not much for the lender to do except verify that loan amount based on the documentation. And once that's done, it's a done deal. And so the timing is just going to depend upon volume. To give a reasonable estimate, I would say anywhere from 3 to 5 days on average.
Yeah, that gives everyone a sense of what they're looking for. Yeah.
Yeah, that would be once. That's not after you apply. That's after the applicant provides all the necessary documentation to accurately calculate the loan amount. From that point, the decision's almost instantaneous at the lender's level, and then it's just working through and getting the corrected the appropriate legal documents out. 3 to 5 days for an automated lender, 10 for other lenders who don't have an automated process. And again, it's going to depend a lot on each lender's volume of activity.
Yeah, no, that's perfect. That gives us a good sense of what to expect as these programs start taking off. Thank you, Pat. Move right over to Donna, who will talk about Wings here real quick.
Hello, how are you? My name is Donna Henry, and I'm the Business Resource Specialist at Wings. And we are here for you. That's the one thing I want to let you know, is that we are here for you. We have all different types of support for you, especially that one-on-one support. We have resource sessions that you can book one-on-one, financial coaching if you need help restructuring your budget. And when I say resource specialist, we'll have someone that can walk you through the various resources that are available and kind of tailor what resources are out there that will fit your needs. We also have an employment coach that will help you navigate through your employment if you are unemployed and how to actually file for unemployment. And we also have small business advising, which myself will and another person can help you navigate through your business and help you with any type of business decisions that you need to make to navigate or pivot your business while you're going through this, while we're going through all of this. And it's easy. You can just schedule online via our COVID page. And we also have other webinars out there that will provide you information and tips, and you could just log on to our website.
Great. Thank you so much, Donna.
Thank you.
Next we'll hear from DVAP and Michelle.
Hi, Fawaz. Thank you so much. I'm Michelle Alden. I'm the director of DVAP, which is the Dallas Volunteer Attorney Program. Like Wings, we are here to help you as well. So we want you to know that we are here to help low-income residents in Dallas County who need civil legal assistance. We can help with a variety of different civil legal matters. Those include family law. That's the majority of what we see. Also housing, landlord-tenant, that looks to be a big issue coming up here with all the COVID issues. Consumer, wills, probate, expunctions and non-disclosures, Chapter 7 bankruptcies. So please let us know if you need free legal assistance with any of these types of matters. You can do that a couple of ways right now. We can't have our usual legal clinics at this time because of the COVID situation, but you can make an application by calling the legal aid line at 888-529-5277. There's also an online application that you can find at the Legal Aid of Northwest Texas website. That's at www.lanwt.org. That stands for Legal Aid of Northwest Texas. In addition to these issues, we can also help you with some different small business issues relating to your business. So if you would like assistance along those lines from a volunteer attorney, I would encourage you for those. I think the easiest way would be to send me a direct email to Alden M, that's ALDEN, M as in Michelle, at lanwt.org. That stands again for Legal Aid of Northwest Texas.org. And we will do our best to help you out. Thank you so much.
Thank you very much, Michelle. With that, we'll go ahead and move into the question and answer section. We've got a few questions that have popped up, and if you haven't had the chance to type in your question, now would be a good time. There's a question and answer function on the Zoom software. And you can type in your question very easily. I'll go ahead and kick it off here. We've got one or two, actually 3 or 4 here right now. The first one is, I'll just read them out loud. An employee sent a company-wide email to a company of under 500 employees that they've elected out of the Coronavirus Act, and that people will not get 10-day sick leave. Question, can they do that? Question, what remedies are available? Riley, this might be up your alley a bit.
Yeah, absolutely. So there are a few scenarios that could be at play here. Generally speaking, under the Families First Act, if you have fewer than 500 employees, you are covered by Families First and obligated to provide that leave. One exception we already talked about, if you have fewer than 50 employees and providing the leave is going to endanger your ability to function as a business, potentially put you out of business, or if certain employees are so vital to your functioning that you can't operate while they're on leave, then you can claim an exemption and avoid the obligations that way. So that's only if you have fewer than 50 employees. Another way, if you're under 500 employees, but you may still qualify to not be covered by the act, is that if you're combined with your parent company or with a sister company. So there are a few different ways that that might happen. In employment law, it's called single employer or joint employer law. So joint employer would be something like you have leased employees and say you're a staffing company, you provide employees to a different company, and then that staffing company's employees plus the company's regular employees combined to be more than 500. In that case, the company can count the staffing company employees to go over 500. So that's one way. Another way is if it's a parent company and a subsidiary that are kind of tied in their operations very closely. So if the parent is kind of closely monitoring the work of the subsidiary, then the subsidiary and the parent might be combined to be over 500. Those are kind of fact specific. It's hard for me to say whether that would apply in this situation. But generally, if you're under 500 employees, you should be providing this leave. I think the second question was, what's your remedy? Right now, the remedy would be to contact the Department of Labor's Wage and Hour Division. If you go to dol.gov, Department of Labor, dol.gov, they have several resources for employers and employees, FAQs, and those FAQs include who you should contact if you think you're entitled to leave and your employer is not providing it. So that's where I would go if you're trying to get those questions answered.
Thank you so much, Riley. That is really helpful. A couple more questions here. I know we're running out of time, but we'll try to tackle as many as we can. We've got one here which might be up for, it might be with CARES Act here, I suppose. We own a commercial cleaning company and have lost accounts and have had accounts suspended. Is there any relief for lost revenue? Question. How can 1099 cleaners be supported to work through these accounts? Dean, not sure if the CARES Act goes that deep.
Yeah, I would say that there's some other portions such as the economic injury disaster loan, EIDLs, and that could be a whole other topic, but is a relatively low interest rate loan with a 30-year maturity date that you can get based off of hardships due to Corona. And so that if you think a loan may be what you need to try to weather out this lower revenue period, that could help you. And then while it doesn't directly affect your revenue by, getting the paycheck protection loan, that is essentially banking 2.5 months of payroll costs that you aren't spending during this period. So the goal is no matter what your revenues are, your overhead for those 2.5 months are covered. So that could be, it's not directly going to look at your revenues and see what happened, but your loss in revenue will help prove that you need either an EIDL loan or a paycheck protection program loan.
Thank you, Dean. And a similar question about independent contractors. Are they eligible for these loans, or is it just through their employer that would have to include them to be part of that loan?
Independent contractors are. It's based off of their 1099 form, and I think they should work. I think the way it's looking is, and this could be Pat might know more, I think the lenders are going to ask those questions, and there's not as much guidance as I would like to be able to give a definitive answer on that.
This is Pat. Can you hear me?
Yes, we can.
The individual 1099 cleaners, if it's a situation where they are performing a job that you would otherwise potentially have as a W-2'd employee, and because I happen to have a building and hire a cleaning company, that is the situation. The individuals probably would not have the payroll data necessary for the PPP program. However, the economic injury disaster loan might be just the ticket for them. In particular, it has a provision that the first $10,000, which is granted quickly, is forgiven. So that, and I'd like to give out this web address because the SBA has put up a really good site that describes the 3 or 4 different programs and the differences between them. And that website is sba.gov/coronavirus. And when you type that in and pull it up, the PPP program's listed, the economic injury disaster loan program is listed, and the application for the EIDL program is directly through the SBA. So you can fill it out tonight before you go to bed if that's what works for you.
That is great advice, Pat. Thank you. Another question here, going through them quick. Regarding the CARES Act, is it only applicable for businesses with employees, or is it available for, are the loans available for businesses that are sole proprietorships or have no employees?
The answer is both. It can work for a sole proprietorship, but the CARES Act really is designed for the payroll protection program element. In fact, the application, although the act itself doesn't specifically say this, the application, and so what would appear to be the guidance that the SBA put out is that you're certifying that you're going to use the proceeds for those eligible items, including principally payroll. The EIDL, I think, would be a better option. That interest rate, by the way, that was mentioned earlier, that's 3.75% fixed. Loan amounts up to $2 million and payable up to I think 30 years, depending upon the purpose.
Thank you, Pat. And that's a good place to highlight. There's so much in this CARES Act. There are so many levels and facets of different agencies working on it. The FDIC could come up with their own program. There's some direct lending abilities. So there are many different subcategories here, and we're only touching on a very few of them. The payroll protection plan being one that's getting the most press because it has a forgiveness element to it and is meant to get into place the fastest. But we are running out of time, so I think we will have to leave it there. Thank you everyone for joining us for this webinar today. We thank our panelists and thank all the attendees. And we hope to keep these webinars coming every so often, and please look to Wings and DVAP for more information. Thank you, everyone.